Same question for you, Mr. Cisco.
Well, I don't pretend to perfection. One of the things that got me interested in becoming a judge in the first place was because as a lawyer I felt that that I was seeing cases where I thought a just decision wasn't reached. And so I've always tried to work hard so that even though bearing an injustice may be a great sign of maturity, I just assume my clients not have to bear an injustice if at all possible. And so I have felt that frequently there have been injustices done in the court system, and I can't, as I say, pretend to perfection. But because of it, and because I know just how awful it is to be a litigant in any kind of a lawsuit, it's just a horrible place to be. Whether you win or not at the end, certainly you'd feel a little better then, but while the whole process is going on, it's just awful. And so I have to tell you, I don't really have any regrets with any decisions I've made. I'm not going to say they were all right. But at the time I made the decision, it was a decision that I felt was right after doing a great deal of work and thinking about it. And so to the extent that Justice Sanders suggests that my criticism of him as favoring the accused means that I therefore favor the government, that is belied by my record. I have represented criminal defendants in private practice many times. I have won cases on behalf of the defense many times. There have been occasions where, I can recall one case in particular where a case came back where they'd lost part of the physical evidence. In the course of the time of going to the appeal and coming back, and it was now being tried in front of me, it had been tried in front of another judge in the first place. And I said, well, this evidence is also exculpatory evidence, and as well as inculpatory evidence. So it tends to convict the person, but it also tends to show maybe he's not guilty. And so I made a judgment as somebody who'd been a trial lawyer for years and a trial judge for years, that it was no longer fair to the defendant to have that case go forward if that evidence is missing. So because the truth-seeking function that the jury is going to make and make a decision about was compromised. And I dismissed that case. The prosecutor wasn't happy about it. They appealed it. That was affirmed. If it had gone the other way, I could have understood that. I've not always agreed with every decision a jury has made, but I respect it. Most of the time they're right. So I guess in a way I'm not really giving you a very good answer, but I can tell you that I know the pain of it. I know the real pain of losing. I know the real pain of having the wrong decision happen. And I work awfully hard to make sure that doesn't happen, and I don't have many regrets about it. As I say, I'm not saying they were always right, but I can tell you this, I tried every one of them, I tried hard.
Thank you very much.
Well, we do have such a thing in the Washington State Supreme Court as a motion for reconsideration, and frankly, when I write an opinion and someone comes forward with a motion for reconsideration pointing out that I've made a mistake, I appreciate it. So we had the unusual circumstance last year of I was randomly assigned a case involving double jeopardy. And I wrote an opinion for the court saying double jeopardy clause did not apply to this particular situation. It was a unanimous opinion. The defense lawyer came back in a motion for reconsideration, pointed out a recent case from the Ninth Circuit, indicated how I was wrong. So I voted to reconsider that case, persuaded four of my colleagues to go along with that. The case was eventually re-argued, and a majority of the court adhered to my original opinion. So I found myself writing a dissent to my own opinion. So so I have no pride of authorship here. I just want to get it right.
Thank you very much.
So a question. Question for all of you. When it comes down to the state constitution, is it a living document, which means that it grows with new rights, or do you believe that the Constitution should be interpreted based on its meaning and original words? Do you believe that?
Is this to the justice first?
All of you. Yeah, any
All answer at once?
Yeah.
I'd be happy to speak to that. Having done a lot of research into the state constitution and looked at the issues in the state constitution, I think that what happens with constitutions is that they incorporate conflicting values. And there are values in our Constitution to protect public safety. There are values to protect criminal rights. and sometimes those values collide. And they collide in rather novel ways sometimes as technology changes, as society changes. And so I think the values are enduring. I think that the purposes of those values are enduring. And I'll, I'll give you an example of that. In the state constitution, there was a big deal about, there shouldn't be railroad passes given to legislators. Well, that's not really much of an issue these days, is it? Whether legislators get a railroad pass so they can ride around on the trains for free. But I think it bespeaks an underlying concern about influence and undue influence over our legislators by someone in power, because in those days the Northern Pacific was really the equivalent of Boeing and Microsoft and PACCAR and all these things combined. It was an enormous powerhouse. And so I think it shows you that there was a concern about concentration of political power in private hands and what that might do. And so I think the values are absolutely enduring. But I also think that anything that any constitutional interpretation has to grow out of the language of the document. You can't just overlay the document with something new and unspoken. You can't put words into the document.
Sure, sure. The Constitution is a kind of contract. It's a kind of an understanding. It's an agreement. This is the power that this is the power that the state has. The people have ratified, and they agree to this. To the extent that saying that the Constitution is a living document means that it changes over time, means that we're somehow going to say that they've agreed to something now that wasn't really agreed to then, and that gets to be complicated. One of the reasons why lawyers and the law rely upon precedent, stare decisis, or whatever you wanted to call it, is because there's an expectation that's been built up, and there's been an understanding that's been built up as the law has proceeded. So the Constitution, when it originally was drafted, there were certain values, as Mr. Wiggins points out, that were embodied in that document, as it is in the U.S. Supreme Court. If we don't try, at least, to honor the plain language of it and honor the intent of it at the time of the founding, then we're now talking about something that wasn't necessarily agreed to. And that was so to the extent we get away from what was agreed to, then where is your anchor for where you go with it? And that's the concern with legal precedent. Is if we don't attempt to stay with the rules that we know them to be, then the law becomes something of a coin toss. It becomes unpredictable. It no longer reflects the agreement that originally arrived at. And it then just becomes the will of the few folks that happen to have that office at the time. And we have to be very careful of that. Because, as I say, judges don't go through the political vetting process that I discussed before. And because of that, they can have values that have not necessarily been agreed to by the voters, for instance. And so while it is sometimes difficult to determine the application of language written over 100 years ago to current day circumstances, one at least should try to do that. If the result looks like it's silly, then we have to deal with that. The example I like to use has to do with the QWERTY keyboard, the QWERT on your keyboard as you're typing. That was originally, the reason for it originally was because so as typewriters would throw their keys, you would tend to have not so many strikes that would foul each other, so the machine could operate more rapidly. But the layout of the keyboard is not the fastest way to type. And so today, as we have keyboards that don't have those throwing types, we don't need the QWERTY keyboard anymore. So we established this, and now it's become a kind of anachronism. We could type faster if it was laid out differently. Should we change it? Well, millions of people have learned to type in a certain way based upon that old keyboard style. And so now the reason for keeping it is different. It's that so many people would have to be retrained to do it differently. And what is the value of that? So I recognize as things go by, the original reasons for them may not remain. But one must be very careful in making those changes because because, first of all, if it's a 5-4 decision of the Supreme Court, we've got one extra judge compared to all the opinions of everybody else, the legislature and so on, that we have to weigh that against.